Hi guys, welcome back to my channel. This is Battle with Ola. My name is Mujala Olua. Today we want to talk about a very important topic. So I want to do a very comprehensive video today on that topic, hoping that when people ask questions in the future or when they need clarifications about this particular topic, this video would suffice alongside other videos that I've done on the topic. Actually, I've done a few videos. If you check the video on injunctions, if you check the videos on charges, and if you check the videos on moving motions and counter affidavits, I think two of those, you would find out that this topic has been dealt with extensively, but it's never too much. And I'm hoping that when this video joins those other videos, if anyone needs more clarification or explanation on them, having watched all of them together or even watching this one alone, it would suffice. So today we're going to be talking about motions. Motions are very important. They're an important aspect of law practice because we can only ask things from the court by way of motions. Motions are prayers before the court. They are the way and the means by which we come before the court to ask the court for one thing or the other. Like people go to church and pray to God. People go to agencies and establishments and request for one thing or the other, or apply for one thing or the other. In court, we move motions. We file motions. We come by way of motions. Motions are the same as applications. They are used interchangeably. So motions are the way by which, we apply to the court to command the doing of an act or to command the restraint from the doing of an act. So motions is what we want to talk about today. Now that I've explained what motions are, you need to know that there are two types of motions broadly. There are several classifications of motions, but the two main types are motion ex parte and motion on notice. Motion ex parte are motions that you bring to the court without notifying the other party. You know that in any lawsuit there must be two parties. That's probably the complainant and the defendant, or the applicant and the respondent, or the petitioner and the respondent, as the case may be. So for motion ex parte, you do not need to inform the other party that you're asking anything from the court, usually because these types of motions affect the other party. So you're trying to, in a manner of speaking, surreptitiously do that thing or get whatever it is you're asking the court for done without them knowing that you're doing it, because most likely they would object to it, or it would affect them in one way or the other, which they might not be favorably disposed to, and the sabotaging of which could affect you or affect your case adversely. So motion ex parte, you do not need to serve the other party. Ex parte means ex parte, without the body, so without notifying the other person. Motion ex parte. And then we have motion on notice. Motion on notice are those types of motions that you have to mandatorily serve the other party. So when you're filing court copy, your copy, and the other party's copy, as many defendants or as many respondents might be in the case. So it's a three-way motion. You have to serve the court. Ordinarily, you have to serve the other party as well. So motion on notice. Those are the two types of motions. Now we have different classifications of motions, based on the rules of each court that you are applying to, or that you are, doing a mattering. So you would need to usually refer to the rules of court to see how you can ask certain things from the court. And that's why when you see any motion, I have a motion here with me. When you see any motion, you would notice that they are brought, pursuant to the rules of court, or to the Constitution, or to some laid down rules or procedure that is applicable and that is in existence, that's in operation in that court where you're asking that thing from. So motions are prayers. They could be ex parte or on notice, and they are brought based on the laid down rules and regulations of the court or of any applicable law under which you seek to bring the motion. Now, let's talk about how to draft your motion. When you're drafting your motion, the first thing that you need is the heading of the court. The heading of the court. For all processes filed in Nigeria, it must be headed in that court to which you're applying. So this motion that I've brought to use as an example was headed in the Court of Appeal heading. because it was filed at the Court of Appeal. Today we are going to be using a sample motion that I have with me here, and it's a motion for stay of execution. It's a motion on notice because the other party has to be served. The other party in this case is the judgment creditor and we are the judgment debtor. So we are notifying them that we have asked the court for stay of execution because we want to appeal the judgment of the court in that matter. We don't want them to execute the judgment because it has to do with property, while the court hears, while we file, our appeal in the matter. I'm going to be using this sample motion today, changing a few things because, I don't want to use the real, characters and content, especially as regards names and, particulars, of people involved in this case. So this is a motion on notice asking the court for stay of execution. You could file a motion for extension of time. You could file a motion, for substituted service. You could file a motion for practically anything. Once you can find the law or the rules of court that supports the asking of that thing from the court, you add the motion under those rules and you come to the court to ask of it as an order, asking the court for these things as orders. So the court will make those orders. Remember that I said that motions are asking the court to command the doing of a thing or to command the refraining from the doing of an act. So this is a motion for stay of execution filed at the Court of Appeal. So the first thing that you see on any motion and indeed on any court process is the heading of the court. So this is headed in the Court of Appeal in the Ibadan Judicial Division, holding at Ibadan, because this process was filed in the Ibadan Judicial Division of the Court of Appeal. You know that the Court of Appeal has judicial divisions. It's not like in every state. It's just in some regions of the country, as it were. So we filed this one in the Court of Appeal, first line, in the Ibadan Judicial Division, second line, holding at Ibadan, third line. That's the heading of the court. Then we have appeal number, we put the appeal number, suit number, we put the suit number. Because this is an appeal, we need to put the appeal number that was assigned to the appeal that we filed, and then suit number for the original matter at the trial courts. So that's why it has those two things. In some other cases, you might just have to put, the suit number and the court number, that is the courtroom in that judicial division, maybe court 13 or court 10, where the process or where the matter will be heard. Then we have the parties between Alaja Badegeshin, a appellant respondent, and Mr. John Ogu, respondent applicant. So Mr. John is the one applying for this, is the one moving, is the one asking this thing from the court, is the one that is appealing the judgment, the existing judgment. So Mr. John is the one that filed this motion. That's why he's the applicant. But he's respondent because in the matter upon which this motion is premised is the respondent, not the claimant or the appellant. It's not the one that filed the appeal, but he's the one asking the court for stay of execution. So we have Mr. John Ogu, respondent applicant. So depending on the court where the matter is and what you're asking the court for, which side of the goalpost you are, that would determine how you would title your parties. So yours could be claimant applicant if you are the person that filed the matter upon which that motion is premised, and if you are the one that then brought the motion to the court. So you would be claimant applicant, the other party will be defendant respondent, and like that and like that. So those are the parties. Then the next thing is motion on notice. That's the subheading. And then for the subheading, we have brought pursuant to section 36(1) Constitution of the Federal Republic of Nigeria 1999 as amended, order 7 rule 2 of the Court of Appeal rules, order 6 rule 1 and 2 of the Supreme Court rules 1985 as amended, section 23 of the Sheriffs and Civil Processes Act, order 3 rule 1 of the Judgment Enforcement Procedure rules, and under the inherent jurisdiction of this honorable court. You have to note that when you're bringing any motion to the court, you have to bring it based on laid down rules and procedures. So wherever court where you were doing any matter, the court rules, maybe civil procedure rules or criminal procedure rules or the court acts, those things are your friends. You have to check them. Be sure that this thing that I'm asking the court has actually provided for it to be asked of it. because the court is not Father Christmas. It will not give what it has not authorized you to ask. It's funny, but that's the way the court works. You have to come under a lawful basis, to ask something from the court. So all the rules that are applicable to you asking that thing from the court, you cite them in this section, and then you finish it with and under the inherent jurisdiction of this honorable court. That's how you finish all your headings for all motions. After you've cited all the rules the way I cited it, we cited the Court of Appeal rules, the Supreme Court rules, Sheriff and Civil Processes Act, because it borders on judgment execution, and that's the law that governs judgment execution, the Sheriff and Civil Processes Act. And then we cited the Constitution as well, and which is the right to be heard. That's fair hearing, section 36. And then we finished it with under the inherent jurisdiction of this honorable court. Please note that as you watch this video, I'd like you to leave comments in the comment section. Let me have feedback from you. If anything is not clear, let me know. And if you've gotten value, please leave it in the comment section. I'd like to implore you at this point to please subscribe to the channel. It helps me. It's very important. I know that I'm giving you value. You keep mailing me and leaving comments to that effect. But I would love for you to, help my ministry. Come on, subscribe to the channel, like the videos, leave comments on the comment section. When you engage with the channel, it improves the optics, and it can be circulated more on YouTube, and more people can get to see it. Beyond that, I'd like for you to share the links with your friends and your foes. If you're getting value, come on, share it with someone. Thank you so much as you do that. So after that, you go right into the motion. The first paragraph, take notice. That's the first two words for any motion. It's written in bold capitals. Take notice. Then comma, that this honorable. At the end of this video, I'm going to leave a sample video of motions so that you can look at these things that I'm talking about here. I don't want to put them here so that they don't interfere with the explanation that I'm providing right now. So take notice, comma, that this honorable court will be moved on the date fixed for the hearing of this application, or such other adjourned date at the hour of 9 o'clock at the forenoon, or so soon thereafter, as counsel for the applicant may be heard in his behalf, praying this court for the following orders. If you bring together 10 unrelated motions in Nigeria today, they would all start this way. That's why I always encourage young lawyers and anyone who is confused about any process, any court process, just go look for precedents. Just go look for samples. Look for what someone has already done, okay? If you're working in a law firm, check their computer, for sample processes. You don't need to start drafting it from scratch. Even if you're at the law school, there are sample draft textbooks and, soft copy materials, study materials that have these things, because most of the things that we do in law are similar. That's why Lord Denning said, God forbid that the lawyer should know all the law, but you should know where to find the law. So you should know where to find these things. Once you get these samples, you will just need to adjust them, in bits and pieces, slot in the names that are applicable, the sections of law that are applicable, and this and that, and you have a perfect document. Nobody needs to stress themselves from scratch regarding these things. So this is how most and all motions are started. Take notice and you finish through the paragraph, and then you begin to ask for what you're asking the court for. Now, I said that motion is the way by which we come to court to ask for one thing or the other, and we come by way of prayers. We pray the courts to grant this or to grant that. Now, when we're asking, we write it as order, because when the court is granting it, the court will be making an order. So that's why we ask the court for order, so to grant order this or order that. So now the first order is an order for stay of execution of the judgment in appeal number. You put the appeal number CA/ blah blah blah. Between, you put the name of the parties, and that's Alhaji Agbade Geshin and Mr. John Ogu, delivered by their lordships, Quorum in brackets, Honorable Justice Jimmy Olukayede Bada, Ugochukwu Anthony Ogaku, and Folashade Ayode Jojo. They are justices of the Court of Appeal, and they are the ones that delivered the judgment, for which we are asking for stay of execution so that we can appeal it. That's why this is. So this is where your own will change, depending on what you're asking the court for. If you're asking the court, for substituted service, for instance, you would probably write something different. If you're asking the court, for extension of time within to file a process that you did not file when you were supposed to file it, it will be different. So this is where you will deviate, but most other things are practically the same. But don't forget, like I always say, nullum similar est idem, nothing similar is the same. So take note. So name of the justices delivered by their lordships, we put the name of the justices on the 2nd day of September 2021, pending the hearing and determination of the appeal of the applicant to the Supreme Court. So if you're asking, for instance, for leave to amend a charge, if you watch the second video on charges, I explained the motions. I even drafted it there live. So you would see that what you're asking will be different, because you will not copy this thing, verbatim. What you are asking, what you put in your orders, in your prayers, will be different. So these things that we ask for, they are called prayers. Okay, you ask the court for all the things you need to ask. If there are 7 prayers you need to ask the court, ask them away. Now make sure that you read the rules of court as to asking those things, and so you must word it appropriately. So you're asking for stay of execution. In some cases, you might be asking for leave of court to do one thing or the other. So you say an order of court granting leave to the applicant to do this or to do that. I cannot, come and explain all types of motion there are or there is, but I want you to understand how these things change one way or the other. They are similar, but the things you're asking for will determine how your wordings will change. And then the last order for every motion is an omnibus order, and that is, and for such further or other orders as this honorable court may deem fit to make in the circumstances of this case, that order is always added to all motions. After you've asked for all other orders, you put that one as the last order, is the omnibus order. Is like the miscellaneous, that if the court wants to grant any other thing, the court is at liberty to grant it. We add it, so that we do not fetter the court to the things that we have asked only, because the court will only grant what you have asked. That's the way the law is in Nigeria. The court is not Santa Claus. The court is not a seer that knows your mind or preempts things for you. So you have to put this omnibus or miscellaneous order or prayer so that the court will know that they are at liberty by your motion to also grant any other order that will facilitate your purpose and what you really need to do or to achieve in that situation. So that's a motion. This one that I've just read is a one-pager. That's a motion. It's very simple. It's the simplest document. I see all your comments and I see all your questions that you mail me at houseoflivingstones@gmail.com. I know that once you try to draft 1 or 2 motions, you will get the hang of it. It's really simpler than you think it is, and I really wish you success, especially for law students that are, preparing for bar finals. That is how to draft a motion. Then you date it, and then after dating it, you put your name, a place for you to sign, your name, your firm's name, your role at the firm rather. So I could put Mojela Olua Livingstone's partner, House of Livingstone's LP, for instance, and then you put your firm's address, and then that's on the right. Then on the left you put address for service, because it's a motion on notice. It's going to the respondent and maybe respondent, the appellant respondent in this matter. So you put for service on the respondent. Now you put the name and the address of the respondent, and that is how you draft a motion. So in most cases in law, a motion is supported by an affidavit in support and a written address. It's not all the time, but most motions come with an affidavit in support and sometimes with a written address. In some cases you don't need a written address, but in most cases you need those 3. They always go together. They are the triplets of law. They always go together: a motion, an affidavit in support, and a written address. So your affidavit, just like any normal affidavit, is where you make the facts of that matter known. That is why you're asking the court for that particular prayer or those prayers in your motion. You put them in your affidavit in support. So as usual, the court heading, the suit number, the appeal number in this case, but in most cases, suit number and court number, courtroom number. Then parties between Alhaji Agbade Geshin, appellant respondent, and Mr. John Ogu, respondent applicant. Then you put title it affidavit in support of motion, and then you say, I, Jessica Ogu, female, adult, Christian, businesswoman, Nigerian. So those are things that start an affidavit. The particulars of you, the deponent. The deponent is the person that is swearing an affidavit. So you have to put your particulars, that is your name, what you do for a living, where you live, and all those things. So now, hi, Jessica Ogu, female adult Christian businesswoman, Nigerian, of number 4 Capital Gate International School, Jos Plateau State. Do hereby make this oath and declare as follows. That's how your affidavit is introduced, starts. And then you set out all the facts in support of what you're asking the court. Essentially, you're telling the court, this is what happened, this is what happened, though. That's why we have to come and ask you for this prayer, so that you can make this order. And you have to prove to the court in your motion as well that the granting of that motion will not prejudice the other party in any way, and it will not wreak injustice. So you say that the applicant, you put your relation to, the applicant, because if you're an applicant, you can't swear your own affidavit. Someone has to swear it, someone that is well abreast of the issue on ground, and they will tell the court how they are related to you and how they are related to the case, how they came to know the facts that they are now swearing to or deposing to. So I am the applicant's biological daughter, and by virtue of which I'm conversant with the facts of this case. That is the first. You number, affidavits are numbered. After that introduction, they start numbering. The first one, number 1, is how you are related to the applicant and how you came to know the facts of the case. So you say that I'm the applicant's biological daughter, and by virtue of which I'm conversant with the facts of this case. That's 1. 2, that I have the authority of the applicant and his counsel to depose to this affidavit or to depose to this oath. That's 2. That's how most affidavits are drafted. Affidavits in support now, because there are also affidavits like affidavit of confirmation of name, affidavit of loss of identity card, and all those ones. They might be slightly different, but for affidavits in support, this is how all of them are drafted. So that's the second. The third is that the respondent's suit against the applicant was dismissed by the trial court in a judgment delivered on blah blah blah. So you begin to explain the facts, that the respondent being aggrieved by the same appeal to this court. You just explain all the facts, all the things that led to the applicant coming to the court, to eventually come and ask for those prayers by motion. So after you have explained all those things, that there are jurisdictional questions or issues in the notice of appeal, blah, 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 that the applicant has been living in the property, it's a property matter, blah, 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 that this application ought to be granted to protect the subject matter of this suit, blah, blah, blah. So most of those reasons, you set them out. And now, I told you the first and second points are always in all affidavits. Now, these following are also in all affidavits. So after you've done the first and second, you state out the facts, and then these last paragraphs, these numbers are called paragraphs, by the way. So these last paragraphs, they are almost always in all applications. It's by law. You have to tell the court. If you watch the video in injunctions, once again, I put them there, that this application is made in good faith and in the exercise of the applicant's right to fair hearing. That one, you may or you may not put it as applicable to the subject matter. But now, that if this application is not granted, the applicant will not be able to reap the fruit of its appeal if it is successful. I taught that in the video on injunctions. I'm sorry that I keep referring to it. Please watch it. So you have to establish to the court that it's important for you to grant this prayer. If you don't, something else might happen. And even if we get judgment at the end, it might not suffice for the damage that would have been done. So please and kindly grant this application, we beg and plead. So 12, that if this application is not granted, the applicant will not be able to reap the fruits of his appeal if it is successful. 13, you say if it is successful because you must not give the court an idea that you can already predict where the court will go or how the judgment will turn out. So very important. You see, court language is very, 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 very particular. You have to be very careful not to insinuate anything at all. So 13, that this application ought to be granted so as not to put the Supreme Court's decision in a fait accompli if the applicant is successful in his appeal. What that means is that so that it will not, the Supreme Court will not have exercised its jurisdiction in vain. That is, when we have judgment and the matter is already done, like the die has been cast, the deed has been done, and we're now bringing judgment later. It will be like, oh, it's too late, just to prevent a situation where the judgment will be too late for execution, or where justice will be impossible to be done, or where it will be impossible to correct something that's been done or to undo an act. so that the Supreme Court will not just embark on an academic exercise or on a fruitless traverse. That's why we're asking for this. And then that this application is sought in the very interest of justice and the respondent will not be prejudiced if granted. You have to put that almost always as the second to the last paragraph of all affidavits in support of motions. And then the last one, that I make this oath solemnly and conscientiously, believing same to be true and in accordance with the oath's acts. In some states, you have to put the oaths acts of maybe Lagos State or Oyo State or Edo State of 2002 or of 2000 or of 2009 or of 2010, just in particular. So that is the end of your affidavit. Note that I said that affidavit is where you explain to the court all the facts and the events that led to you bringing this application, why you have brought this application. And you cannot swear your own affidavit if you are the applicant. It has to be sworn by someone else that is probably connected to you enough to be able to tell the court that I understand what is going on here. So that's why your first paragraph, the introductory paragraph, is where you give the court your name as the deponent to the affidavit, your name and your particulars, and then you number your affidavits, and the numbers are called paragraphs, but they are numbered 1, 2, 3, 4, etc. So the first will tell the court how you are related to the applicant, the person that brought the motion, and how you are connected to the case. And the second is to tell the court that you have the authority of that person to actually swear this affidavit. Then you go on and state the facts as you understand it and why the applicant has brought the application and what the application will do if granted. After that, you tell the court in the last few paragraphs that one, the other party will not be prejudiced if the application is granted. That two, justice will not be compromised if the application is granted. That three, if the application is not granted, it might occasion injustice and whatever might have been done, it might be impossible to undo it if the application is not granted. And then you tell the court also that it's in the interest of justice to grant the application. And lastly, that you have sworn or deposed the affidavit in good faith and conscientiously believing all the facts stated in it to be true and in accordance with the Oath Act or the Oath Law as appropriate. Then underneath, you sign and you put deponent. You will see it in the sample that I will put at the end of this video. You put deponent, you sign. That's on your right underneath. Then on your left, you put sworn to at the Court of Appeal Registry. You put the registry of the court where you're swearing is. So here, sworn to at the Court of Appeal Registry, Ibadan, or your state. And then you date it this 24th day of October 2021. You put it. And then underneath, you put before me, space, line, Commissioner for Oath. That's where the Commissioner for Oath at the registry will stamp and sign that you have filed it at the registry. And that is how to draft an affidavit in support. Now, for written address. Written address is where you argue, the facts of the matter as stated in your affidavit and why you have brought the motion. You argue, you make the court. You know that in Nigerian courts, we no longer do oral arguments largely. So you need to argue in your written address. Prove to the court that you got to grant me this application. If you don't, it will occasion injustice. I know that you've stated it in your affidavit in support, but now in the written address, you have the opportunity to argue it as if you were arguing live. And by arguments, we are not saying that you will just be giving opinion. No. Argument is that you bring laws, decided cases in support, of your case. So you edit as per usual, the heading of the court, the appeal number, suit number, court number, then the parties, then you write written address in support of motion. Every other document, affidavit or written address, they are in support of the motion, the prayer before the court, the first document. So now, introduction, you will explain what happened and why, you have brought the application. Oh, the court gave judgment, as in this case now, the court gave judgment. We were dissatisfied. We don't want the other party to execute that judgment before the court will hear our appeal. That's why we have brought, this application or motion or prayer for stay of execution. That's your introduction. Now, the issue for determination, the second thing in every written address. The issue for determination now is that whether the applicant has shown special circumstances to be entitled to the order for stay of execution. Now, legal arguments, that's where you argue this issue. This issue, the issue that you set out, that's what you argue in the legal argument. So this is the issue for determination. For every written address, there must be an issue for determination. Even in the final written address for substantive cases at the trial court, you have to have, an issue for determination. Whether, for instance, election petition, whether this person was qualified to stand as candidate on the platform of PDP or APC or whatever. So you have whether this and that should happen, whether the applicant is entitled to this prayer or this order from the court. Then you now make your legal arguments. You explain, dictionary meanings and decided cases, case law, all manner of things, mostly case law. You argue to show the court, to prove to the court that I am actually entitled to this order for stay of execution. In so case, the court decided that if a party brings this kind of application, it should be granted once he has shown that this and this and that. In so decided case, the Supreme Court decided that a party should be granted this application if he can prove this and that. In the so decided cases, it was also similar, and the court also held that so and so and so. So you argue your case before the court in this written address, and then you conclude. Conclusion must link back to the issue for determination. So you tell the court that you have been able to argue it, and so the court should grant your application. And you say thank you, or you say we are most grateful. You remember I said it's an argument. So instead of doing it orally, you're doing it verbally. So if you were doing it orally, you would say thank you. So you put thank you or we are most grateful. Then you dated this 16th day of October 2021. Then you sign, you put your name, your position in the law firm and the address. You can put your email and phone number too if necessary. At the Court of Appeal, I know that they insist on phone numbers. Sometimes they even insist on passport photograph of the lawyer or the counsel that's filing the application, or the applicant himself or herself now, not even the lawyer. So yeah, that. And then you put for service, address for service, and that is it. So if you refer to any exhibits are samples. For instance, if I'm talking about this kind of application, and for instance, we were asking for stay of execution. In our affidavit in support, where we were stating the facts, we have referred to the judgments that we are asking the court to stay for us. So that becomes an exhibit. Exhibit is any document you refer to in your affidavit in support. So you number it Exhibit A, Exhibit B, Exhibit C. So if you have referred to anything like that, you tell the court that this is Exhibit so and so, and you attach it to the process when you are filing it. Because if the document you refer to in your affidavit in support is not attached, the court will discountenance it. Because whatever you don't put before the court, even if the court knows about it, the court will not think about it or give cognizance to it. So it's important for you. And note that you only refer to documents in your affidavit in support, not in the written address, and not in your prayers. So that is how to draft the triplets: motion, affidavit in support, and written address. So I hope that you've learned one thing or the other. Now let's go to the third aspect. I hope that you're enjoying this video so far. If so, give it a thumbs up and don't forget to subscribe, please. It does a lot of good to me. I haven't been paid by YouTube, not a dime, since I've been making videos, and I learned that there's some payments that can accrue to me. It would be nice to get paid, doing what I love, and it would be nice if you would support that. So if you're so minded, and I know that you are, please subscribe to the channel and spread the word. Share my links with your friends and your foes. Let them also come and get value. Let them come and leave comments. Let them come and ask their questions. Let's help each other. I really enjoy and love talking about law. It's my favorite thing to do. And so if I could make some money off it too, it would be really cool. So please don't forget to like the video and subscribe. Let's go to the third aspect of today's video: how to move a motion. There are already about 2 or 3 videos on that already, but let's add this one to it. So on the day that the court gives you the hearing date that you should come and move your application, you come to court, you announce your appearance. May it please the court, O.M. Livingstones for the applicant. In this case, I am for the respondent applicant. So I announce my appearance. Once the matter has been called, I say, may it please the court, O.M. Livingstones for the respondent applicant. And the other person will also announce their appearance. Then the court will say, what's the position of the matter, or what are we here for today? Like some judges like to ask. So you say, my lord, we have a motion before the court. The court will ask, have you served the other party since this is a motion on notice? So you say, yes, my lord. Court will ask them, have you been served? They will confirm. So you tell the court, my lord, we are ready to move our motion. They ask the other party if they filed a counter affidavit, which is a response to a motion. They will say, my lord, we filed our own counter. We are also ready, or we are equally ready. So now the court will ask me to move my motion. This is how to move my motion. Note that you can either move fully or move in terms. Moving in terms means that the court trusts you enough to ask you to just move in terms. So if the court says move in terms, you just say, my lord, I move in terms as on the face of the motion paper. So that means that the court will just read through your documents that is already before it. Remember I said you file a court copy too. And then they will ask the other party to move also. If they are also moving in terms, they move in terms, and then the court will make its ruling. So you don't have to read it out. The court does that to save time, and it does that also for trusted counsel. But there are some courts where you go to and they will insist that you must move it in full and not in terms. That's because some lawyers have been known to smuggle in what Justice Bayo Taiwo calls Toronto documents. Justice Bayo Taiwo was the judge when I did my externship, so I always remember him a lot for so many things. So he calls it Toronto documents, that is Oluwole documents that are forged. So history has it, or story has it, according to him, that some lawyers will file something before the court, and then they will come to court with something else. And then on the day that the court asks them to move in terms, after they've moved in terms, the court will grant that motion. Meanwhile, they will now go out telling the whole world that the court has granted B, which is what they brought, not what they put before the court. The court will think that what is before them and what is the lawyer is moving is the same as it should be, not knowing that the lawyer has changed what they have. So the lawyer will go about touting that the court granted something different and something of the sort. So that's why some judges do not allow lawyers to move in terms. You have to move fully. Also, if you're a young lawyer, some judges will insist that you have to move fully so that you can learn. So since we are also trying to learn in this video, let's move it fully. So I'd come and say that, my lord, we filed a motion dated 16th day of October 2021 and filed on the same date. So the date that you put on your motion is the date that you announce. That's the dated. But the filed is the date that you file it. So you can print it from your office and date it one date. And then you take it to the court to file it the next day or the next week or the next year. So the dates will be different. But you have to tell the court the day it was dated and the day it was filed, so that the court will trace its own, the one in its own file, and see that it's the same thing, that's the same motion that you're referring to. This as is done so that there are several motions in the file or in the case. The court will quickly be able to find the one that you are moving at the moment. So you say, my lord, our motion is brought pursuant to Section 36 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, Order 7, Rule 2 of the Court of Appeal Rules, Order 6, Rule 1 and 2 of the Supreme Court Rules, 1985 as amended, Section 23 of the Sheriff and Civil Processes Act, Order 3, Rule 1 of the Judgment Enforcement Procedure Rules, and under the inherent jurisdiction of this Honorable Court. Our motion is praying this Honorable Court for an order of stay of execution of the judgment in appeal number CA/IB/ blah 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 blah. You put the number and the date, between Alhaji Agbade Geshin and Mr. John Ogu, delivered by their lordships, Honorable Justice Jimi Olukayode Bada, Ugochukwu Anthony Ogaku, and Folashade Adejojo, justices of the Court of Appeal, on the 2nd day of March 2021, pending the hearing and determination of the appeal of the applicant to the Supreme Court, and for such further or other orders as this Honorable Court may deem fit to make in the circumstances of this case. So you can see that I'm reading out just as it is, but I just read out, the orders that I have. So that's what you read out. So you tell the court, my lord, we equally filed a 15-paragraph affidavit in support of this motion Deposed to by one Jessica Ogu. My lord, our affidavit is dated 23rd day of October 2021 and filed on the same date, my lord. My lord, we also filed a written address. We'll be relying on all the facts in our affidavit in support, and we'll be adopting the written address as our argument in this case. We urge the court to grant all our prayers. We're most grateful. That is how to move a motion. Basically, you're telling the court the documents that you filed and what they are for, the dates they were filed, the people that signed, and what you want to use them for. So it is that simple. We filed a motion, we filed an affidavit, a 15-paragraph affidavit in support. It was deposed to by so and so, and then we also filed a written address. We are adopting the written address as our argument, and we are relying on all the facts in our affidavit. We urge the court to grant our prayers. We are most grateful. That is it. That is how to move your motion in full, and then the court will now ask the other party to move their counter affidavit. That is if they have responded to your motion. There's a video on counter affidavit. I'll leave a link to it in the description box. You can watch it so you know how to, move a counter affidavit. So that is all about motions. The meaning, the drafting, the filing, the documents attached, and the moving of the motion. That's all I have for you in this video. It's been one long video. I hope that you watched to this point. If so, thank you so much. I'm glad that you did. I know that you have gotten value, and it's been a pleasure, putting out this value. Don't forget to subscribe to the channel. I will see you in my very next video. Toodles.